Welcome everybody to the talk on how to handbook the sociology of law, given by E.G. Privan, James Campbell, and Monica Arango today. First of all, I would like to thank the three speakers for accepting to give this talk. And of course, I want to thank all of you for being with us. It has been a very pleasant surprise to have received so many registration forms. Before talking about the talk and the speakers, let me introduce the Oñati community and the aim of these online meetings. If any of you is not yet member of the Oñati community, we invite you to visit our platform and join us on the web oñati.community. You can share your projects, exchange your ideas, upload blogs. You will also learn a lot about the Basque culture. And of course, any of you could suggest proposals for different webinars and talks. We would be very happy to support you. With these events, we would like to bring together alumni, faculty, and friends of the Oñati International Institute for the Sociology of Law to discuss some of the most pressing and contemporary socio-legal problems of our time. We started these webinars last May with a series about socioeconomic inequality in the Global South, particularly in Latin America, but also in Africa last November. The next one would be the pandemic and the indigenous peoples, and we are already talking about it with Professor René Coupe from Austria. Those online conversations create a friendly space in which alumni and faculty have the opportunity to reconnect and to engage in an intellectually enriching dialogue. Oh, sorry. So as I was mentioning, the two of the speakers today are PhD students, so we hope that we are looking forward to hearing them before the PhD defense. Another series we are thinking on is about indigenous peoples. As I have mentioned before, the first talk will have probably relation with the pandemic, but there will be others about indigenous peoples in different countries. We have already contacted people from Venezuela, Ecuador, Canada, Peru, Mexico, Chile, many countries. If you are interested, please get in touch with us. So today's talk will consist of E.G. Privan's brief introduction of the handbook, followed by Monica and James' comments, insight and criticism, after which we would like to open as much space for discussion as possible. All three participants will discuss the process of editing a research handbook on the sociology of law, especially connecting its origins and genealogy with current state and future ambitions. The session will be recorded, so you might want to turn off your camera and microphone once the talk begins. The recording will be stopped at the end of the talk so participants can engage in an enriching discussion. And now let me introduce the speakers. A special pleasure for me to welcome the three of them, because as I have mentioned to them before, I like this professor of the master's program with a student of the master's program debating together. E.G. Privan is a master's professor of the International Master at the Oñati Institute, and James Campbell was his master student in one of these years. And James and Monica both are PhD students. So E.G. Privan, he is the director of the Center of Law and Society at Cardiff University. E.G. Privan graduated from Charles University in Prague, where he was appointed professor of legal theory, philosophy, and sociology. He has been visiting professor or scholar in several institutions: Florence, New York University, Berkeley, University of San Francisco, Pretoria, Brussels, Sydney. Has published extensively in the areas of social theory and sociology of law, legal philosophy, constitutional and European comparative law, and theory of human rights. His monograph, Sovereignty in Post-Sovereign Society in Routledge, was awarded the SLSA Socio-Legal Theory and History Book Prize. His article, Reconstituting Paradise Lost, Temporality, Civility, and Ethnicity in Post-Communist Constitution Making, published in Law and Society Review, won the SLSA Hart Socio-Legal Article Prize. He is the founding director of the Center of Law and Society and editor of the Journal of Law and Society. He regularly contributes to the Czech and international media, a lot of things. And James Campbell, he's a PhD candidate at the Center for Socio-Legal Studies at the University of Oxford. Having joined Warsaw College and the University of Oxford in 2020, his research explores the significance of physical movement within the court building, drawing upon legal architecture, the jurisprudence of the senses, and the application of mobile methods. He is an associate lecturer in law Society and Culture with the Open University, and editor with the Scottish Legal Action Group, Legal Journal, and section editor with Frontiers of Socio-Legal Studies. He holds law degrees from the University of Strathclyde, the University of Edinburgh, and of course, of the University of the Basque Country at the Oñati Institute, International Master in Sociology of Law. In the chat, you can see their web pages. Mónica Arango, she's PhD in law candidate at Oxford University, is graduate research resident at the Bonavero Institute of Human Rights, editor of the Center for Socio-Legal Studies blog, Frontiers of Socio-Legal Studies, and the Mr. and Mrs. Kenny Lamb Scholar at St. Catherine College. She holds a Bachelor of Laws from Los Andes University in Colombia and an LLM from Harvard University. She was Deputy Justice at the Colombian Constitutional Court and Regional Director from Latin America and the Caribbean at the Center for Reproductive Rights. So thank you again to the three of you. And so I give you the floor. You can start whenever you want.
Okay, Susanna, thank you very much. And it's my absolute pleasure and great privilege to be back in Oñati, if only spiritually, but it's wonderful to see the building of the Institute and so many colleagues and friends who I had an opportunity to meet over there. And I should speak very briefly and introduce the Handbook, which is a collaborative work of many people. And I think it's the very opposite of what the dark side of academia might be. The dark side of academia is that we live in a very individualistic, competitive, narcissistic, and egotistic environment of university lectures. But we also live in the unique environment in which we can collaborate, share ideas, and welcome mutual criticisms and enjoy the academic exchange of ideas and friendship and company of our community. And Oñati was always one of the symbols of this bright side. So there are two sides of academia, and Oñati represents the bright side. When we started putting this handbook together, it is an outcome of many collaborative networks, many academic contacts around the world. And it's not just Cardiff and the Center of Law and Society with the Oñati Institute, it's also Cardiff and the Oxford Center for Socio-Legal Studies Institute. And it's my great privilege that the feedback today will be given by two PhD candidates there, Monica and James, but also we have other participants and contributors to the book from over there, and they are our wonderful friends and colleagues. Fernanda, Bettina, Linda. It's also the outcome of collaborations of the Oñati people in Colombia, Brazil, and people from Central Eastern Europe. So I should say this is my assessment of the book, of the handbook, that the unique aspect of this book is that it's established on already established platforms. What did we want to do and why did we want to do it in times when there are so many edited books that if you approach somebody about the possibility of having an edited volume, they would tell you, oh, not again. So there is a certain skepticism about edited volumes. But the opportunity came from the publishing house of Edward Elgar, which is one of the most progressive independent publishers in specializing, apart from other fields, also in socio-legal literature, to offer the handbook, which could be used selectively, and people could download individual chapters. So it is very handy for the most diverse fields of sociology of law today. And the idea behind the handbook is pretty simple. Rather than, we all know it, we socio-legal scholars, that some people really indulge in making distinctions between what is socio-legal studies, what is law in context, law and society, and what is sociology of law. The philosophy behind this editing work was, let's not go back and revisit these discussions. Let's build a handbook on the assumption that sociology of law is a traditional, well-established discipline, and it's been with us for 100 years, and 100 years plus at least, and that we could revisit rather the relationship between sociology of law and other disciplines. So we examined interdisciplinarity and its impact on sociology of law. There are some amazing chapters on legal theory, sociological jurisprudence, but also ethnography, anthropology, science, economy. And so this was one task. Let's examine this. Let's examine also sociological concept or sociological meaning of basic legal concepts such as legal subjectivity, temporality, space, visuality. And all these sociological inquiries into basic legal concepts form the second part. And the third part, which I believe is extremely useful for lawyers and legal scholars, is that we offer sociology of specific legal disciplines. So there is sociology of family law, sociology of transitional justice, sociology of constitutional law, and I could go on like this, and you name it. And so these are three basic questions which form the structure of the book, which may inform people interested in sociology of law for the first time. So it should be the handbook for the beginners, for those who are coming from outside, but also for those who work in this field and want to be informed about the latest developments. Finally, and here I will stop, I think we managed to produce a piece of work which is wonderfully balanced in terms of gender. We try to reach out to other parts of the world, but still I have to confess that one of the drawbacks was that this is profoundly Anglo-centric handbook, so it comes from the Anglosphere, You have UK, you have the United States, you have Australia, you have European scholars, and we eventually didn't manage to get contributors from Africa, Asia, and Central Eastern Europe. And this failure, I hope, will lead to the second volume, in which we will really inquire into the global sociology of law, but it will be a different handbook rather than just a sequel to it. So after this confession of what didn't work in the end, and what I think on the other hand worked pretty well, I'm passing the floor to Monica and James. Thank you.
Thank you, Jirgi and James, and above all, thank you, Susanna and the Oñati community for having invited us today to this conversation. It is an absolute pleasure to be here, to see so many people on the 20th of December, when the world seems to be collapsing with Omicron and everybody seems to have like a lot of things. So this interest is just wonderful. So as I've said, it's been a pleasure to read the book and to try to comment on it. And it's, I think, an incredible, ambitious book, I have to say, which manages to set out its aims and accomplish its aims wonderfully. So it's impossible to comment on every chapter, and although I have many thoughts about so many of them. But I just wanted to focus my very brief comments on more like the question that brings us today together, which is how to handbook the sociology of law. So, as I've said, the handbook articulates a rich and comprehensive perspective of the state of the field of sociology of law. And it sets to map the historical, theoretical, methodological context, and as a complex social scientific research of positive law in Jerry's words, not mine. And I think that the handbook really accomplishes this in two ways. The first one is in the way in which the handbook is structured, precisely as Jirgi just mentioned, first setting out what are the boundaries of the discipline, then about the concept of law and the legal systems, and then about the sociology of the legal systems. But not so evidently, I think that the accomplishment of this aims about the historical, theoretical, methodological perspectives are accomplished in the structure of each of the chapters. I think that even though it's not evident, it seems as if there had been like very precise questions about first trying to define concepts and problematize each concept within like each of the topics by explaining what each of those are understood today and how they have traveled within time. Then it sets them within the context of historically where did they start, where have they come, and then each of the contributors brings on their own perspective to take a stand on what this have been, and then also more importantly they set a future and agenda and questions for future research. So it's not just about looking back, but it's also about looking into the future, and this is why this structural part and each of how the chapters are determined in throughout the book. I feel that this is why they make such a contribution, because they're giving you the past, the where we stand, and the possibly where are we going from incredible and magnificent scholars. And this in reading this, in seeing these two perspectives, I thought that what came to mind to me, or my thoughts about it, were questions about the internal and the external limits of the discipline. So the first part really tries to track the interdisciplinary and transdisciplinary boundaries of the sociology of law. And it made me think that if we think about that this is about law, right, and law in context for sure, is there a limit to the sociology of law, and how is it speaking with all of these different disciplines, right? So, and it brings me back to the other ambition, or to the other aim of the book, which is also to track the methodological aspects of sociology of law. Well, these are transversal through the entire book. There's no chapter defining or saying this is the methodology of sociology of law. So it made me think about, is it now though how we are seeing what this handbook is saying, is that the sociology of law has captured or taken within it the inter and transdisciplinarity of the boundaries with other disciplines? Is this what has happened? And the methodology of sociology of law right now is an inter and transdisciplinary position or perspective that is taking in legal history, economics, legal anthropology, ethnography, and so forth, and has brought it in to make it theirs. So that was like one of the questions. And also in thinking this, I was thinking, okay, so is there a limit to sociology of law, or anything that has to do with law is sociology of law nowadays, on how we think about it, right? So I thought, and for example, it comes to mind, there's no, in that first part, there's no part, for example, talking about political sciences. Is there a limit there? Is this the same, or is this something different, right? And thinking about the internal limits, and of course, coming from the Center for Social Legal Studies, I cannot not ask the question about the internal limits of the discipline. While the aim, as Jirgi has mentioned, is to say sociology of law, we're talking about law and society, we're talking about law and context, we're talking about social legal studies. I do wonder if this is, if for example, this had been a handbook on social legal studies, would have been different. And if that would have looked different in a different way, because when you read throughout all the chapters, different authors do take a stand and do mention law and context, law and society, social legal studies, and I don't think that they choose those words or those concepts or that positionality in a way. They have thought it through. That's what I mean to say. So I also wanted to inquire about if within those different perspectives, is there something maybe methodologically that would have been different? And then in thinking about also those internal boundaries within the sociology of law, I think that the questions that are always answered in each chapter about what is the law, what is legality, how is the law built, and how and what, why, and what is legality, what is constitutional law, what is the rule of law, and around like moving around all of these methodological questions. But there is few there's not a lot, I mean, about the question of what ought to be the law. This normative dimension of this is how the law should be looking today. Maybe that has to do with geographical assumptions. And for me, this is a very pressing question, because from my background, I come from a background of practice in law, of constitutional law, from a very activist court, which is thinking about living law and legal change all the time, from a litigation background, where the questions that are posed there are what should be the law normatively, right? So I was wondering if this is something that escapes or doesn't escape the sociology of law right now, or this is something that has to do with the intertwining with other disciplines as political sciences, probably. And finally, my last remark, which I also thought that was super interesting about the different chapters, is that in many of them, you see a theoretical commitment there that really explores what is law, how is law, these questions that I mentioned. But in the chapters that deal more thoroughly with what is the methodologies, for example, ethnographies. They are talking about more a walking towards, or a journey towards, a sort of relativization of knowledge and the sociology of law, where positionality comes in very strongly in saying where we're walking towards is more, it's the same big questions that give answers that are more tailored to, in a way, subjectivity, or where we're coming from, while these theoretical chapters still are aiming or making claims that are much more universal about how we think about law. So I saw these two strands in different chapters that I thought were very interesting, and I'm very curious to see, like, from this meta view, what are the thoughts about how do you make sense of these two strands. So these are a lot of questions, because this is a fascinating handbook, and the one last thing that I just wanna say that about it, that I think that was also magnificent, is the way in which chapters talk with each other. That is something that you normally don't see when you read handbooks, and the fact that they are referencing each other and having read each other is just fascinating. So I'll leave it there and pass it on to James.
Hello, everyone. It is an absolute honor to be here, albeit digitally, to provide some brief commentary on Professor Preben's wonderful handbook. Of course, it's an excellent resource, but it's also one that's prompted in myself a lot of reflections about the discipline of the sociology of law, its nature, its limits, and also its relations to proximate fields of study. I should say also, on a personal note, it's a pleasure to be back as an alumnus of the Institute, a former student of URI, and also somebody who's had the pleasure of continuing to work with the professor periodically over the years since. I think first and foremost, commenting upon a handbook is a difficult task, and especially within the time constraints. I would say it's the project behind it is a mighty scholarly undertaking, and it's produced a weighty but by no means bloated tome. It's provided also a strikingly broad treatment of the field. Of course, it's been marshalled and edited by the polymathic and polyglottal Professor Preben, a prestigious, prodigious and prolific author who seems to write more books more quickly than I can read them. The contributors to the volume are also a veritable who's who of leading thinkers in the field at large, but also, importantly, pioneers in their respective subdisciplines. Given this, I'm going to try to limit comments to more broad observations about the handbook and the process of handbooking, the verb to handbook, rather than skirting over excellent individual contributions. As has previously been noted, the handbook's structured in three parts. The first, Sociology of Law Beyond Disciplinary Boundaries, is principally concerned with mapping the margins of the field and articulating the interactions between sociology of law and cognate disciplines. The second part, the sociological concept of law and legal system, turns to fundamental legal concepts and long-running debates therein, as seen through the sociological lens. And so we look at the rule of law, living law, legal systems and cultures, and so on. These contributions breathe new life into staples of the legal sociologist's diet. But the section also features topics that have often and regrettably been overlooked until now, such as time and temporalities, and gives them a deserved place at the table. Lastly, in part 3, Sociology of Legal Disciplines, the volume seeks to apply the sociological gaze to particular areas of positive law, contributions that do not become bogged down at a doctrinal level and in the study of the particular, but rather go beyond this to draw out a broader applicability and an appreciation for something that is more universal. And so, how to handbook? As Professor Preben notes in his introduction, and also in a recent piece he was kind enough to write for Frontiers of Sociolegal Studies, his intention was not to tread the same ground in the same ways as earlier handbooks, encyclopedias, and journal special issues have. We can see different approaches are taken by different editors for different handbooks. While some attempt to be encyclopedic, others elect for featuring more detailed and original scholarship on relatively small topics, perhaps more in the style of standalone journal articles. Regarding the latter, I think there's a question there about whether a handbook ought to take that approach, or whether such an approach would fail to provide the breadth of coverage one hopes for in a handbook. However, I think it's absolutely clear that when handbooking, there is a balance to be struck between breadth of coverage and depth of coverage, and moreover between originality and originalism. Pribben's rationale, and I would describe a kind of editorial emphasis for how a handbook of the sociology of law ought to be oriented, is cogently expressed in his introduction. Firstly, rather than a purely contemporary or momentary presentation of the field, it ought to reflect and reflect upon the development of the field. It needs to, and I quote, connect the discipline's origins and genealogy with its current state and future ambitions. Secondly, a handbook must be conscious of similarities and divergences between sociology of law, sociolegal studies, law and society scholarship, and so forth. But it also must not be beholden to artificial academic borders. Lastly, a handbook for the sociology of law should discuss its canonical knowledge and concepts as much as possible and ways of moving beyond them. The professor's emphasis on the discipline's origins and genealogy, as well as its canonical knowledge and concepts, made this particular reader reflect upon whether the sociology of law as a discipline, as a scholarly community, and as an intellectual tradition is indeed more aware of and perhaps more committed to its forebears than the closely entwined fields of law and society or socio-legal studies, which is to say, whether the sociology of law is more imbued with a particular quality of traditionality and of intergenerational continuity. More generally, I would love to hear from the professor about whether he thinks handbooks by their nature are intellectually conservative endeavors. Do they constitute restatements of the status quo, a totalization of the field? Are they inherently intellectual closure of a discipline? As to the other handbooks, there's a considerable variety on the market, as the professor notes in his introduction as well. There are also very clear differences, not just in terms of approach, but in terms of topics covered and methodologies embraced. And I think that goes to demonstrate the diversity of work in the field, a particular vitality and a plurality of approaches that are being taken, and also a spiritedness of debates. It might also, particularly when we compare handbooks from the US versus the UK, speak to a distinctness of our research communities despite the globalized world we now live in. In some sense, perhaps it also denotes us speaking past each other, in addition to the disparate opinions on methodologies and worldviews. In preparing for this event, I found it was an interesting exercise to compare Professor Pribben's handbook with the Routledge handbook edited by Valverde, Clark, Darian Smith, and Kotaswaran, a handbook that was published a few months after Professor Pribben's. Valverde et al. Advanced a more explicitly critical and perhaps radical account, given that the editors share a post-colonial, anti-racist and feminist perspectives and a commitment also to social justice. Valverde's handbook, however, does omit several staple methodologies of the discipline from its coverage of contemporary perspectives and approaches, and that's the title for that part of the text. tacitly, they opt instead to cover critical race theory, post-colonial legal studies, and queer theory. Part one of Professor Preben's handbook, by contrast, features more of what one might expect and more of what one could see as being the prevalent methodologies and perspectives in the field as it currently stands. The structure of Valverde's collection as well is distinct from Preben's. Valverde's is, broadly speaking, of vignettes, 52 chapters, which allows for very broad thematic coverage, but at the inevitable sacrifice of some depth of coverage, and many contributions are only 4 to 5 pages in length. And so I would put this one to the learned professor as well. As to your capture of the field, what themes, topics, methods, or voices are or are not included? How did you as an editor decide that? And are there particular lacunae, either in the forms of topics or methodologies, that you would like to fill perhaps in your future volumes? And so I will close with just a few words about the usefulness and utility of the handbook. I would say it is sufficiently approachable in style and substance, as well as the actual size of the chapters, that students and early career scholars will find considerable value in it. But researchers at all career stages, I think, will find worth in the varied contributions, particularly when they're coming to a new area of work or to a subdiscipline that they are not intimately familiar with. And I would highlight that's of particular importance in the increasingly interdisciplinary academic world. The clarity and succinctness of the contributions within the volume make such transdisciplinary engagement both entirely feasible and indeed pleasurable. Of course, one could treat the handbook as a reference tome, picking it up for a particular chapter when one has a particular purpose in mind. It may even tempt some readers to expand their horizons, either for that given piece of work or for some future project as of yet at the thinking stage. However, I think the handbook could also serve another purpose. It could serve as the central plank for research training for doctoral candidates in the sociology of law, given that the handbook provides space for such a wide range of theoretical perspectives and in turn their application. The experience, I would say, of reading the handbook was to see renewed the sociology of law as a broad church, as being able to contain work from the philosophical to the concrete, and to cover inquiries undertaken at many different levels of abstraction, from the theoretical to the applied. I shall close by just noting that perhaps the sociology of law is like pornography. I have difficulty defining what it is, but I know it when I see it. Thank you very much.
Thank you very much, Monica and James. I will have to think about the last statement and what did I actually do in it, so many great insights, so many thoughts. I will speak very briefly because I think we have a unique opportunity here. I saw in this event, I saw a number of people who actually contributed to the handbook. So they may tell you completely different story, and they may say, oh, never again. I will never contribute to a handbook like this. Or, but what Monica said about this cross-referencing, I probably should mention that this handbook is an outcome not of a conference or a series of conferences, but really of shared pool of knowledge and networks. And so all contributors wrote the first draft, which we then circulated. We read each other's work and then critically reflected on our own chapters and incorporated different chapters into our individual, our own chapters. So yes, cross-referencing was a deliberate way of constructing, of making this handbook. Monica, you make a comment about methodology, and you both listed a number of works in Sociology of Law, Law and Society, or Sociolegal Studies, which have been published in last 2 decades. Yeah, we had David Clarke's Encyclopedia of Law and Society published in 2007. We had the mini library Law and Society published by Cowan, Mulcahy, and Wheeler in 2014. The Handbook of Law and Society by Surratt and Hewitt a year later. Then the Journal of Law and Society had special supplement on May currents in contemporary sociology of law. And the Routledge Handbook was mentioned here. So the question was, how do you want to, what is not being mentioned so much? So the idea was that each contributor will write from her or his specific field of interest and bring in methods, themes, concepts, and trends. Trends was, again, a planned attempt to avoid this, what James correctly described as the risk of conservative closure of the field. This is what we are, or rather like canonical reading of sociology of law. No. These are trends, and they may turn out to be completely different. Yeah, and I really liked what you said, Monica, about positionality. It is a very trendy word. It's a sexy word in current social science research. And sometimes I'm struggling with it because I don't know whether it is just a replay of interpretive sociology or humanist sociology goals of the 1950s of people who forgot about Erving Goffman and now want to reinvent it for what James described as post-colonial, gender, queer, and issues of social justice, or whether there is something much more methodologically intriguing, yeah, that where does sociology of law begin and where does it end? Is it endless or not? And here I will stop with my own experience, my own position, if I may use my own position as a scholar coming from Czechia, and learning that when you end up in the United Kingdom, you realize that law is a young science. Yeah, if you study law in Central Europe, of course, it's right next to the theology. And what is sociology of law? For lawyers, it's, if you're useful at all, give us methods to make law more efficient. And sociologists very often say, no, we are giving you the most general theory of law. That's why theoretical hints are there. In the United Kingdom, nobody asks questions of positionality of sociology of law like this. We're doing sociolegal research, which is very often taken as normatively charged. You mentioned no normative assumption. Yeah, normatively charged, de lege ferenda, what law should be like in terms of social justice, racial equality, anti-discrimination legislation, and it is very much shared within the UK sociolegal studies. And then you come to the United States and you realize that, yes, law and society is alive and kicking there, but it is done by social science, political science, psychology departments, but it is always gonna remain, to use my favorite author's title, before the law. Yeah, you will always end up before the law. And these experiences are somehow, of course, present in the structure of the book, and what James described as how do you want to move forward, or what are the challenges? Obviously, I absolutely love what Walbert, Kreuzfeld, and the rest did, that very short chapters, basically they are like a manual. Yeah. Our handbook, I don't think is a manual. It's not a canon, but it is almost like a synthetic piece of collective work on the current state and possible development of the discipline. And here I'm going to stop.